All right, excellent. Welcome. I am Teresa Miguel Stearns, Associate Dean and Director of the James E. Rogers College of Law, Daniel F. Cracchiolo Law Library. It is my pleasure to welcome you to this very special collaboration between the Law Library and the college's Alumni and Development Office. This combined LawCats Live and Faculty Book Talk series event features Professor David Gantz in conversation with Professor Andrew Shepard to discuss Professor Gantz's book on the United States-Mexico-Canada Agreement, also known as the USMCA or the new NAFTA. David Gantz is the Samuel M. Fegtly Professor Emeritus of Law, as well as Director Emeritus of the International Economic Law and Policy Program. He is also a non-resident fellow at Rice University's Baker Institute for Public Policy, Mexico Center, with a focus on international trade and economics. Professor Gantz teaches and writes in the areas of international trade and investment law, regional trade agreements, public international law, and international environmental law. Professor Gantz is the author or co-author of 6 books and more than 75 law review articles and book chapters. He has served as a consultant for the UNDP, USAID, and the World Bank. And he has served as an arbitrator in multiple proceedings under chapters 11, 19, and 20 of NAFTA. Over the course of his distinguished career, Professor Gantz was a visiting professor of law at American University and George Washington University Law Schools, a lecturer in law at the University of Pennsylvania, and visiting assistant professor of law at the University of Costa Rica. Professor Gantz has also taught at Georgetown University, Loyola University, the University of San Diego Law School, and Universidad Rafael Landívar in Guatemala. Prior to entering the academy, Professor Gantz served in the Office of the Legal Advisor, U.S. Department of State, and practiced law in Washington, D.C. He is a graduate of Harvard College and Stanford Law School. Andrew Shepard is a College of Law Professor of Practice, Associate Scholar, and Deputy Director for Global Faculty. He is a 2-time Wildcat, earning both his bachelor's degree and his law degree from the University of Arizona. He graduated cum laude from the College of Law, was editor-in-chief of the Arizona Journal of Environmental Law and Policy, and was the recipient of the college's Munger Prize for Scholars in International and Business Law. From 2012 to 2014, Professor Shepard worked as an English teacher at Tsinghua University High School in Beijing. He has been teaching in the College of Law's global program since earning his law degree, both here in Tucson and at the university's microcampus at Ocean University in Qingdao, China. Professor Shepard's courses include American Public Law, International Trade Law, and Introduction to Procedure. Please join me in welcoming Professors Gantz and Shepard to our live audience here in the College of Law Faculty Lounge and to our virtual audience as well. It is a true pleasure to share this event with so many colleagues, friends, and alumni, many of whom I suspect were students of Professor Gantz during his nearly 30-year tenure here at the College of Law. Thank you.
Thank you, Teresa, and thank you all for being here. I want to start off by saying how much of an honor it is to be here, as Professor Gantz was my professor when I was back a student here. So for regional trade agreements, he's my note advisor. He's been a tremendous friend and a wonderful mentor. So it's rather surreal being here next to you. I also want to congratulate you on this book. This book is a wonderful description of all the changes that the USMCA has made to NAFTA. And you've done it in a way that is accessible to those who are not trade nerds, but also informative to those of us who are unfortunately cursed with liking international trade. I want to start off with the reason for you having to write this book to begin with. That in 2016, President Trump described NAFTA as the worst trade deal in all of history, echoing complaints that we'd often seen from the left prior to 2016, describing this as the reason for the death of the manufacturing sector and the death of the middle class in America. To what degree do you think that those critiques have merit?
Well, I think there are pieces of them. I think, frankly, blaming Mexico and Canada for what mostly was caused by moving of jobs to China is a little bit unfair. But Mr. Trump, in fairness, picked up on that very quickly as well. I mean, NAFTA was negotiated 30 years ago. When it was negotiated, it had some major defects, mainly in the way it did terribly bad. I won't say terribly bad, I'll just say an ineffective effort to deal with labor and environmental issues, which over the last several decades have become a key aspect of trade agreements. I think for its time in 1991 and 1992, it went beyond most other trade agreements. At the time, it dealt with intellectual property, for example. It had a relatively robust dispute settlement mechanism. And it obviously made it possible for Mexico, Canada, and the US to compete as a unit with what was going on in Asia and the European Union, particularly in things like automotive industry, but others as well. But of course, by the 2016, it was clearly woefully outdated.
So you mentioned labor and environment, and NAFTA was originally negotiated by the H.W. Bush administration, but signed by Bill Clinton, stating that he would sign it on the condition that there were adequate provisions for labor and the environment. So what areas needed improvement if NAFTA did indeed address, to some extent, labor issues and environmental issues?
The problem is labor and environment were an afterthought, as you point out, because Mr. Clinton promised during the campaign that if he would support NAFTA, but only if we added labor and environment. And that was done back in May, June of 1993. But it didn't go very far. There was no effective dispute resolution mechanism. And I think it's fair to say that many of the trade people in all three countries were not, shall we say, enthusiastic about dealing with those areas in the trade agreement.
Was there greater enthusiasm in renegotiating for the USMCA?
I think a lot changes in 25 or 26 years. First of all of the trade agreements concluded, particularly by the second Bush administration, that was the big time for doing trade agreements, had labor and environmental provisions that were much, much more advanced than anything in NAFTA, like being subject to the regular trade dispute settlement mechanisms. And I think by 2020 or 2017, at the time when Mr. Trump either was going to get rid of NAFTA entirely or amend it, it was quite clear that to get it through Congress, it was going to have to deal effectively, much more effectively with labor and environmental issues. And I think if you look at the negotiations, there was really very little resistance to either of those provisions. I mean, the Democratic Congress added provisions to make the labor mechanism much more enforceable in December of 1919, but the basic agreement went much further than the Trans-Pacific Partnership or any other regional agreement done by anyone, including the EU, in terms of dealing with environmental and trade issues. So I think there was a huge change. Back in the 1990s, many in Congress, mostly Republicans, but some others said we shouldn't be connecting trade and environment or trade and labor. Those are separate issues. That disappeared 25 years later. So I think there was a lot of progress in the way people looked at these issues that made it much easier, not easy, but easier to negotiate USMCA.
As the former head of the Environmental Law Journal, I have to ask, what are the substantive changes in the environmental law section, and are they adequate?
The last part first, we don't know whether they're adequate yet because it's only been enforced for a couple of years. It looks very promising. What do they do? Basically, it had to do with changing Mexican law, and Mexico changed its own law in making it possible for the first time ever to have independent labor unions formed by labor organizers who are protected under USMCA, to have open and free union elections and open and free collective bargaining, which eventually we hope will replace the standard Mexican arrangement where you have unions making sweetheart deals with their own, essentially with the companies, leaving most of the labor people in the dark as to what's going on. And also to enforce this through a so-called rapid response arbitral mechanism, which I think does a reasonable job of assuring that these provisions will be enforced, at least based on the first two cases.
So here's another critique of trade agreements in general. People sometimes say that trade agreements are a vehicle for the US to impose its values, or to impose its economic might. So are these provisions on the environment and labor, are they US economic imperialism, or are they in your opinion, likely to lead to substantive, meaningful environmental and labor reforms within Mexico?
Again, it depends on your point of view. From a view as an environmentalist, these, I think, have to be major steps in the right direction. Will they be sufficient? They're already being enforced. I mean, the US essentially told Mexico that small boats which were violating environmental laws in terms of fishing in the Gulf of Mexico could no longer land their cargoes in the United States, which essentially means there's no point in doing the fishing because they're not going to sell them in Mexico. The environmental provisions really are very similar to what 12 countries accepted, 11 countries beside the US accepted in the Trans-Pacific Partnership. And it's hard to argue that the US was bullying Japan. In terms of Mexico, Mexico exports 80% of its goods to the United States. So they have relatively little flexibility when they are dealing with the US and the US insists on something. I think early indications are that both the labor and the environmental provisions, if they are paid attention to by the US in terms of enforcement, will improve things in Mexico. A different administration, which does not really care about those issues, which did not enforce them, will change the whole approach entirely. So I think it depends a lot on the level of enforcement, the ability to which Mexico and the US can agree on changes that need to be made. And frankly, again, still too soon to know how well that's going to work, but I think early indications are promising.
You mentioned enforcement. Skeptics of international law will often say that international law is too theoretical, that it doesn't have an effective dispute settlement mechanism, that its enforcement is solely diplomatic. To what degree is NAFTA or trade agreements in general different than what skeptics of international law are referring to?
Well, at the moment, the US and Mexico and Canada are engaged in a third-party arbitration mechanism over how rules of origin for autos are to be enforced and how foreign parts in the transmission, for example, are to be treated as part of a finished product, which is all North American, or have to be traced through. That's not very theoretical. That is basically a very set of very important details, which are going to mean billions of dollars to different auto and auto parts manufacturers over the next 10 years. So there's a lot that is theoretical, obviously, in the whole process, but this is a very practical agreement in many respects.
What about dispute settlement or enforcement of environmental and labor provisions?
We don't have much experience with that because there's only been one major case. It was in an agreement with Guatemala, and the panel essentially found against the United States. The basis for that agreement, which I won't go into given the time limitations, was changed rather substantially in the USMCA. So basically the assumption is if there's an environmental violation, it affects trade instead of the reverse. And I think when we start getting cases, and we will, I think soon, in the next 6 or 8 months, on environment, the chances of the panels enforcing them will be very, very high.
Okay. Now, a lot of people, when they think of trade agreements, they think of trading goods, they think of trading services, of a physical product or physical service crossing the border. But NAFTA and many trade agreements include investment sections. So can you explain what the purpose of an investment section is?
We're talking about mechanisms designed to allow foreign investors to bring arbitral actions against host governments when they commit alleged violations of things like national treatment or fair and equitable treatment or direct and indirect expropriation. These provisions have been around since the 1970s in bilateral investment treaties. They're deeply embedded in Chapter 11 of NAFTA. They're found to a lesser extent in the USMCA, but the idea is partly to encourage foreign investment in countries that need it and want it, like Mexico. And partly, and I think this is sometimes lost sight of, to get governments out of dealing with investment issues at high diplomatic levels, because it's almost always a major problem. It interferes with other diplomatic efforts. And since the time of Peruvian expropriations back in the 70s, it seems to have made sense to get these into a third-party arbitration mechanism where they have less chance of dominating political relations. So I think those are the two major issues. The Trump administration and many Democrats in Congress would say yes, but first of all, it makes it easier for American companies to move jobs and investment overseas. And we don't like that. So we're going to try to reduce it. And they did it in the USMCA with the enthusiastic support of a lot of Democrats in Congress who have been criticizing NAFTA for 25 years.
So you mentioned that most international investment provisions contain requirements to provide natural treatments, which for those that are not trade nerds means that you have to treat domestic products or domestic investments the same as foreign investments, or MFN, which means you can't discriminate against outside countries. Fair and equal treatment, direct expropriation, where the government comes in and takes something directly. You mentioned indirect expropriation. What is indirect expropriation?
If you are Mexico, for example, you change the rules so that solar energy and wind energy producers who were guaranteed certain rates for transmitting electricity on government-owned power lines no longer apply, and they're going to go sky high, and these companies are probably going to go out of business. They will argue that they have indirectly expropriated. Nobody took over their solar panels, but they just made it impossible for them to operate in a profitable manner.
Has the USMCA changed these provisions at all?
Yes, it eliminated ISDS between Canada and Mexico entirely.
What is ISDS?
Investor-state dispute settlement. Sorry about that. The Trump administration, as I mentioned, did not want to encourage investment in other countries, and the Canadians, for a variety of reasons, none of which are entirely clear, decided they were prepared to give up the ISDS mechanism. With Mexico, ISDS is maintained, although it's modified in fairly significant ways, particularly for disputes that do not involve government contracting arrangements and things like hydrocarbons and electricity.
ISDS is frequently criticized, and it's the subject of many discussions at UNCITRAL at the moment, for being something that infringes upon sovereignty. Here, this is a private company that is going to avoid the use of domestic courts and then use a private arbitration mechanism to effectively say that a legitimate regulatory measure is an example of expropriation. So are the ISDS changes here justified?
Depends on your point of view. From a point of view of a foreign investor, it may not be. The Fifth Amendment to the US Constitution doesn't really appear anywhere else, including in Mexico. You do not have the same protections for foreign investors in Mexico, in the courts of in Canada, foreign investments in Canada that you do in the United States. There are also many countries where the rule of law, to put it mildly, is weak. And therefore, investors, I think, have some legitimate concerns that the courts will be either corrupt or poorly educated or biased in favor of the national government, particularly if you're trying to sue the national government. And I think there are a lot of examples in many, many countries where that has proven to be the case, not entirely excluding the United States.
You don't find it at all perhaps an example of Uncle Sam being paternalistic, saying that Mexico gets these ISDS provisions, but Canada, no?
I think probably it took place because American business people convinced the Trump administration that we were going to need protection with Mexico that we didn't need with Canada, particularly in such areas as hydrocarbons and electricity. And certainly the last 3 years, in my opinion, have proved that to be very much the case. The Mexican government, current government, has changed the constitution to erode the rights of investors in clean energy, including a lot who are in Spain and Italy, in addition to the United States. They have canceled petroleum concessions that were granted by the previous administration. So I think the wisdom of having arbitration available for foreign investors, US and otherwise, in Mexico has already been proven to have been a very wise decision.
Okay. As we're here in Tucson, Arizona, I have to ask, what part of the USMCA is most applicable to Arizona business?
The best way to answer that question is to say USMCA did not do anything significant to erode the very generally beneficial relationship between American agriculture, where we export grain and meat and things like that, and we import labor-intensive fruits and vegetables like that. I would say didn't change it. Small farmers that were hurt in Sonora or Chiapas are still harmed by America. They cannot compete with American grain and pork producers or chicken producers. But the biggest fear, I think, from Nogales groups, the Fresh Produce Association, and tomato exporters, for example, or blueberry exporters, was that mostly the status quo was maintained over the objections of the Florida congressional delegation. And in fact, the Trump administration managed to find a way to restrict tomato imports anyway, but it was not part of the USMCA. And up to now, at least, the efforts to restrict it further, blueberries, for example, the ITC terminated a case in favor of Mexico by ruling in favor of Mexico. So status quo is what we hoped that Mexico hoped for and mostly got. Canada ended up opening up very slightly its dairy market. There's been a dispute over that already. But if you look at it, dairy is insignificant, $600 or $800 million a year compared to the imports of fresh fruits and vegetables from Mexico, which are billions of dollars a year.
President Trump said before negotiations for USMCA began that he was going to rip up NAFTA or renegotiate for something that was significantly better for American workers and American companies. So now that it's negotiated, concluded, ratified, is this something that you would say is significantly better for American workers and companies?
It depends on what American workers you're talking about. If you're a union worker employed in steel or aluminum or autos, it's probably better because it's going to very likely mean, in terms of North American auto production, which is mostly for the US market, a higher percentage of autos and auto parts are going to be produced in the US in the future, and less in Mexico and Canada than in the past. So if you're one of those hundreds or maybe a few thousands of workers who get the jobs, that's good. If you are a service worker who is getting paid 10 or 12 or 15 or even $20 an hour in services, and the cost of autos and washing machines and everything else is going up substantially, I don't think you're better off.
So on the whole, is the USMCA something that is a positive step or a positive is it an evolution of trade law, or is it something that is perhaps a devolution?
We don't know yet. I think in terms of labor and environment, it's all positive. In terms of modernizing a 30-year-old agreement in such areas as digital trade and changes in intellectual property and services, it's a huge positive. NAFTA was very badly out of date. In terms of investor-state dispute settlement, depends on your point of view. I suspect it's going to mean disputes with Canada over investment issues in the future, but I don't really know that. I think in the auto industry, it is a significant negative. It's going to hurt the auto industries in Canada and Mexico, and it's going to make cars more expensive in the US, which means they're going to be less competitive worldwide, all for helping a few hundred thousand, a few tens of thousands of workers at most.
What about on the whole, NAFTA through USMCA, that people will often criticize NAFTA, now the USMCA, as being very harmful to farmers of corn in Mexico, or being harmful to indigenous rights in Chiapas, or something that caused negative social externalities such as violence against women in the border region along the maquiladoras. So A, is there validity to those critiques? And B, would you say that the USMCA / NAFTA regional integration on the whole has been good for the region?
Again, I think NAFTA and USMCA are necessary factors for economic development, for improving the lives of people. They're far from sufficient, as Mexico learned to its costs. in the first 10 years of NAFTA, where there was sort of, I believe, there was sort of an assumption that NAFTA is going to take care of all the problems. And you still needed reform. The corn that US was exporting to Mexico didn't really start in large quantities for 15 years. Mexico was supposed to use that time to help the farmers of Chiapas adopt. They didn't. In terms of the maquilas, I think particularly with the labor provisions around, that the quality of the employment of Mexicans in the border areas is going to increase, although very gradually and maybe not as much as some people would like to see. I think it is better than having those people unemployed and maybe deciding to come to the US, for example. I think it's a mixed bag all around. I think border pollution is a problem, and it's going to get worse because most of the new investment in Mexico today is going into the borders, mostly so you can get American natural gas. And I think in other areas, it's quite a mix as well. I don't have any question that some jobs which were in the US as of 1994 ended up in Mexico and then 10 years later moved to China, particularly in Texas. Levi's closed a 5,000 person plant in South Texas and moved it to Mexico in 1995 and 1996. So there clearly has been some negative impact on jobs, probably nowhere near the magnitude as with China, but still there has been some. On the other hand, a lot of new jobs have also been created both in Mexico and the United States, and it's really very hard to accurately assess what the balance really is.
I want to close on something that I found really interesting in your book, that you said that the USMCA was not just something that was putting band-aids on NAFTA or just updating what was really needed to be modernized, but that negotiators had in mind future trade agreements, that they wanted to set precedent for future agreements with the EU, with the UK, maybe another universe in another century with China. To what extent have, it made me think, to what extent have trade goals changed over the past 30 years?
Well, certainly in addition to what we already talked about, labor and environment, there is much more concern of giving, particularly in the investment areas, of allowing host governments more flexibility in dealing with things like police power and non-discriminatory environmental regulation. I mean, these are obvious necessities. Trade agreements much more likely cover what we would have thought about as non-trade issues, intellectual property, digital trade. I think modern ones like the TPP and the USMCA reflect some of the changes that have taken place in the world economy over the last 30 years, as you would expect. They also reflect the realization that trade liberalization is not going to take place at the WTO in Geneva at any time soon. If there is going to be some liberalization and some modernization, improvement of regulatory processes, it's going to be in regional agreements. Unfortunately, the US is not going to be participating in these beyond USMCA. They're not going to rejoin the TPP. They're not going to conclude an agreement with the EU, and they're probably not going to do very much with Asia either. So, but others will be working in this direction, particularly the EU and China, and it's too soon to tell what the new agreements will look like.
Are you optimistic about the future of North American integration?
Not yet, at least. I think when you have a situation where two of the three presidents, the Biden administration and the Lopez Obrador administration, really don't consider North American integration a significant priority, that makes things difficult. On the other hand, as we try to compete in future years more with China and the European Union, and we are unwilling to do any new trade agreements, I think the importance of a vibrant North American economy will become probably more important to future US and Mexican presidents.
Thank you so very much.
Thank you.
Thank you, Professor Gantz. I'm happy to take a few questions. Yes, sir.
I have a question. Thank you, Professor Gantz. You were my professor. I enjoy your class a lot. One of my favorite areas. I have a few questions, but I'll try to be as much concise as I can. So as you know, Mexico is going through an energy reform. And my question is, to what degree do you think this reform may affect the new redesigned USMCA? And talking about indirect expropriation and the posture of the Mexican government on, possibly changing the energy sector to alternative methods of energy. but at the same time, using, I heard that they're doing the refining petroleum, which is not really an alternative energy. But I see the world doing that, especially in these times, like relying on this energy, type of energy, fossil energy. How do you see this future?
Well, starting with the last part first, I think it's quite clear that the world economy is going to be relying on petroleum to some extent beyond what would be ideal in terms of climate change. And keep in mind, we're talking about plastics as well as fuel. I think Mexico is putting itself in a position to be passed by these areas by trying to revert to the control by Pemex and CFE, that's the electric monopoly. That was the practice back in the early 70s, for example, which is what Lopez Obrador seems to want to do. I think along the road, there are going to be a number of very bitter disputes, mostly under NAFTA, where you can still go to arbitration until the middle of next year, and then also under the USMCA, since it does cover electricity and hydrocarbons. And I think the decision that the Supreme Court earlier in the last few days, 7-11 majority, that essentially said, if I interpret it correctly, that the electricity rollbacks reforms are not unconstitutional, simply means that more of these cases will leave Mexican courts and end up in NAFTA or USMCA. And meanwhile, Mexican oil production will continue to decrease. Mexico will not be able to build pipelines to move natural gas away. And on the whole, Mexico's obligations under the Paris Agreement become further and further from being met. And maybe this will be reversed in 2.5 years when we have a new president in Mexico. And maybe it won't, because we obviously don't know who the next president will be. But I think this will be an increasing problem, particularly for an administration like the Biden administration, which I think is seriously concerned about climate change and green energy, and looks south and says things are not working.
So, well, first, thank you, Professor Gantz and Professor Shepard, for facilitating today. My question is regarding, you touched earlier on this early successes of the new RRM in the labor provision, so in Matamoros, Kicillof. So I'm wondering if you think that that structure of an enforcement mechanism could be applied to future either new trade agreements or amendments, or if you think that that success is kind of contingent on the close relationship, both in proximity and in political dealings with Mexico, between US and Mexico.
To be very blunt, we have clout with Mexico that we don't have clout with most other countries. I mean, the idea of our going back into the Trans-Pacific Partnership and saying to Malaysia and Vietnam and Brunei, those were the three that, as you remember, were subject to bilateral agreements under the original TPP. You have to comply with this system that we put in for Mexico. I think the answer will be a very quick no way. I think if it doesn't necessarily affect the UK, because we don't have to worry about their labor agreements. And frankly, certainly this administration is not going to consider negotiating any other FTAs as well. Who knows what will happen in 2025, but if it is Mr. Trump or somebody like him, they won't be negotiating the agreements either. So that being said, I don't think it's very realistic for Democrats in Congress to assume that everybody will do what Mexico did in this case.
Other questions? In the back.
So one of the things you talked about near the end was Northern America integration and competition as a unit against Asia and European markets. Can you talk about the reasons for doing that? Like, why does North America want to compete as a unit? Is it just tactical, geographic reasons, or why put ourselves as a continent against the rest of the world?
All of the above. I mean, one of the original objectives of NAFTA was to give American businesses, and to a lesser extent Canadian businesses, an easy place to do more labor-intensive work. This was, I think, driven largely, but not entirely, by the automobile industry, and it was reflecting what was beginning to happen in Asia and what was already happening in Europe and in the countries that were at that time and soon would become EU countries. Europe, Germany and France and Italy had Eastern Europe. China had a variety, and Japan and China had a variety of options in Asia, keeping in mind that a big part of auto production is very labor intensive. And if you move that kind of auto production to the US, you can do it, but it's going to make cars much more expensive and less competitive worldwide. And I think those were the driving factors behind, one of the driving factors behind NAFTA. I think there was also concern, both in the Bush and the Clinton administrations, that if this thing worked, it would improve the lives of many people in Mexico and Canada, as well as in the US, a concern which it seems to me has pretty much been lost lately.
So there's a question. Oh, go ahead, Simon.
Just trying to see what else I should say brief. Yeah, so I think that basic concern of looking at the opportunity to look at North America as an economic union, where you do have some lower labor cost production available, and where co-production in autos and textiles and lots of other things has been the rule for the last really 30 years, is still, I think, is still a valid concern. And I think it's even more important today than it was in 1993, because the chances of multilateral trade liberalization are pretty much zero. It's not going to happen in the WTO. Everybody pretty much recognizes, whether they like it or not, that if you're going to have trade liberalization, it's going to be in regional agreements like the TPP or China's RCEP, or some of the agreements that the EU is busy doing all over the world. And since we're not going to do any more agreements by our own self decisions, we're going to have, I think in the future, we're going to have to rely more on North America as a unit to help us be competitive worldwide.
So there's a question in the chat regarding China.
Say again?
A question in the chat about China.
Okay.
My former home, the beloved Middle Kingdom. The question refers to the trade war that was initiated in the Trump administration and asks if the Biden administration has implemented any meaningful changes in the US-China trade relationship, and what the future of that relationship might be, and what the problems and obstacles that the two countries face.
Anything else? First of all, no, I don't think there have been a lot of meaningful changes, and I think, as we discussed in class today, it comes from the fact that it's almost impossible to figure out what they should do. You have $360 billion worth of penalty tariffs that are still in force. You have some retaliatory tariffs from China. You have China, which has increased its imports from the US to some extent over the last 2 years, but not to the limits provided. There have been some, I think, marginal improvements in intellectual property and financial services access, but not major, because the big problem is Chinese subsidies of all of the areas which are part of the so-called Made in China 2025, like electric vehicles and batteries, and artificial intelligence, computers, and the like. And I don't see China backing down under Xi or the current Communist Party for any of those things. And I don't know how politically Mr. Biden could unilaterally lower tariffs in any meaningful way, because he would be skewered both by Democrats and Republicans in Congress. So I don't see any change coming in the status quo. I think there may be incremental things that could be done if the two administrations were a little bit more rational and, I won't say friendly, but willing to talk to each other more significantly, which is really difficult, of course, obviously, in part because we are concerned with the condition of Muslims in China and Hong Kong and the South China Sea, and threats to Taiwan, which I don't think Mr. Trump is nearly as concerned about as Mr. Biden is. But even that being said, it just, you look at this and you see a lot of criticism of what's going on with the status quo, but I haven't seen a heck of a lot of good suggestions as what he should be doing instead. I mean, make the exceptions a little bit easier to access, sure. But what else? I don't really see much hope for an improvement overall in the trade war relationship.
Yes, I remember learning in my international investment law class, for the tendency of creating an international human rights court where dispute resolutions can be discussed there. And the arbitration mechanisms of countries of developing economic countries or countries who don't have the infrastructure like the court, the judicial system internationally. And like Mexico, I see Mexico more like protecting the rights of the people, human rights, international human rights. And you mentioned that one of the main purposes of investment, direct foreign investment, is to develop the economy, regional economy and regional economy, and to improve the lives of the people. And which, after all, developing economies need that, But at the same time, I wonder what the mechanism of arbitration mechanism consists of. Do they choose arbitrators every country and they're subject to a certain court in the United States, or they choose a forum, legal forum? I can't recall that in this area.
There's been a lot of experimentation over the decades and none of it very successful. For example, the ILO, which is not strictly human rights, International Labor Organization, but has a lot of overlap with human rights, has never had any significant enforcement mechanisms. And that's mainly because the members do not want any significant enforcement mechanism. For a while, there was a 1798 statute which provided some basis for jurisdiction on human rights issues. Help me with the name of it.
I don't recall.
What was it?
It made it possible. The Philartica case, for example, made it possible to have for U.S. courts to have jurisdiction in that case over a Paraguayan member of the police who had tortured a Paraguayan citizen, and by some coincidence they were both found in Florida, and therefore they could actually prosecute it. But the Supreme Court has pretty much undercut that entirely. It doesn't apply to all the corporations, and it basically hasn't worked very far.
Alien Torts Claim.
What? The Alien Torts statute, which has been rather steadily eroded in the last 10 or 15 years by the Supreme Court. Although I think there are legitimate concerns about whether U.S. courts should be adjudicating claims that do not affect American citizens. I think the short answer is nobody's figured out a good system yet.
Thank you. First of all, again, thank you. This is amazing. I would like to ask, going a little bit back to the part of China in the competition and the importance of North America working as a bloc, economically speaking. China has started doing a lot of advances in Mexico. A lot of the products companies are starting to settle up in Mexico and start to expand to other places in Latin America, but are starting also to consume the market that was traditionally for the last 30 years for American products in Mexico. Is that something that will damage the idea of the US is working with North America as a bloc, or is something that the US has already considered of happening, that Mexico is probably the one that is going to start shifting or something different? And how important would that be to the US, and especially now that we have this new agreement?
Well, I think for, if you want to be blunt about it, other than with Mexico and more recently with immigration issues that involve the northern tier Central American countries, the U.S. traditionally has not paid a whole hell of a lot of attention to Latin America. They get, many administrations have gotten concerned by Cuba over the time, and certainly Latin America, the leftward movement of Venezuela has been a concern in recent years. But I think if you said American policy toward the hemisphere, toward Latin America, has been one of not so benign neglect, that would be a pretty accurate statement. And I think in terms of Chinese activity in Mexico, it depends on what it is. I mean, you have had many Chinese, Japanese, Korean, Taiwanese, and European investors building factories in Mexico to serve the US market. And I think that will continue. And unless Mexico says, no, you can't invest here, I think it will continue as well. I doubt seriously the Trump administration would do that. There was a scandal, with the Peña Nieto administration about building the trans-Sismic train. I don't know how that turned out. It's now being built, I think, without Chinese investment. But I think Chinese policy in terms of continuing to invest and increase its influence, sometimes in a benign way and sometimes in not a very benign way, is going to be something the U.S. better be willing to deal with, not only in Mexico, but in Latin America and Africa, and certainly in many parts of Asia as well. I wish we could be more proactive in those areas, but there's certainly very little evidence of it that we are being proactive in Mexico or for that matter anywhere else.
Further questions?
Thank you. Professor Gantz, you said that the USMCA improved and modernized some of the intellectual property provisions. Could you elaborate on that a little bit more and maybe even compare to the TPP?
I think there's a fairly close evolution between TPP, intellectual property, and USMCA. I think the big difference with, again, the US has been focused, I was going to use the term obsessed, with protecting the pharmaceutical industry against generics. The USMCA backs off a little bit from giving the pharmaceutical industry such power with the local governments. It does take into account, and some of this is in the TPP and even agreements before the TPP, giving a little bit more concern to individual governments' ideas of how they ought to deal with some of these pharmaceutical issues, given that in most parts of the world, the biggest buyer of pharmaceuticals is the government under its public health systems. The US is obviously a major outlier in those areas. So I think the USMCA moves somewhat toward giving the Canadian, Mexican governments a little bit more flexibility in how they deal with, for example, how soon do you release confidential test data, for example, and how difficult how easy is it for a branded pharmaceutical product to get an additional 5 years or so of patent protection against generics. So I think there is definitely a movement away from some of the things we were trying to achieve back during the second Bush administration, again, because the House Ways and Means Committee had a huge impact on the ultimate text of USMCA. So I think that is probably the biggest.
Oh,
I have one more last question, if you don't mind. I'm sorry, I like this topic. As far as I understand it, correct me if I'm wrong, trade also comes in forms of not only in goods, exchange goods or services, but also in education.
In which?
Correct? Education, cultural exchange.
Well, services certainly does.
Right. You mentioned about the regional exchange between Arizona and Sonora. I'm from Sonora. I'm from University of Sonora, and I'm in the AJD program here. And I noticed that some universities have agreements, like for exchange cultural programs. And I think it is important to have those partnerships in which I remember attending one of the conferences here 3 years ago, and you were there, International Trade Law with Dr. Robert Robbins, talking about the need of establishing that partnership with University of Sonora, for example, in Hermosillo, to have students coming here, studying here in programs. I know Governor of Sonora signed some sort of agreement with ASU to have some exchange in education. Just would like to know your input on that. What do you think about that approach?
Well, Andrew and I have discussed this in the past, and I have been pushing Andrew and also Professor Tweed. I think it's great that we have a relationship with Ocean University in China. I think it's been very beneficial for us and for them. I think it's great that we're probably going to have a relationship with Hanoi. We'll see regarding it in a couple of days. I would really like to see closer relationships with Mexico, and there have been some progress here. Chris Gast has worked on this for great extensive. There's more going on with UNAM, and particularly with the UNAM office in Tijuana. There's at least a possibility that Monterrey Tech in Guadalajara is working out arrangements, so there will be an expansion on the legal side. They have operations, but not law in Hermosillo. And it would be wonderful if we could make that a three-cornered program. I think it would be hugely beneficial both to us and to Hermosillo residents as well as to Monterey Tech. So I think there are a number of, using a bad cliche, irons in the fire, and hopefully it will be possible to develop it. Can you add to that?
All I can say is stay tuned. There's another question here that I want to get to before we leave. We're at time, but I think this is a perfect note to end on. Professor Cohn is asking if we're entering or if we have already entered a fundamentally new era for international trade. And if so, what do you see as the most important features of this new environment?
Well, one of the big heads of the venture capitalists that basically said last week, which has been widely quoted, well, it's the end of globalization. I don't think it's the end of globalization, but I think it's a very different globalization. And I think basically if the changes that are taking place very, very clearly in the public eye today really started back, certainly at least as early as the Great Recession, and some would argue with the WTO disaster in Seattle in 1999. But clearly there is going to be some decoupling with China. There's going to be some reshoring or hopefully nearshoring, that means Mexico or Canada, with China. And I think more and more companies will do what most of the auto industry does already, and that is they will make their goods in places that are much closer to where the consumers are. I think some of this could be very, very beneficial to North America. I think basically one has to be really careful where you substitute Chinese or Mexican labor for American labor and not getting the costs out of line, both for worldwide competition and for people of limited means who maybe don't want to spend $50,000 or $60,000 in a new car. So I think this is a huge risk. I think it's also a risk for climate change because if electric vehicle costs don't come down, a lot of people simply won't buy them. And when you have battery costs going up because lithium and copper have just gone out of sight in terms of cost, this has not only an economic impact and impact on people's welfare, the cars they drive, but also on whether global warming, whether climate change measured remediation can take place at time to save the planet. So I think it's pretty important stuff. But yes, I think there is a fundamental change. I don't know how far it's going to go. It's made worse, obviously, by the Russia-Ukraine war. We are what, 8.5% inflation rate last month, and that's not going to go away, I don't think, for a very long time. So there are going to be lots of changes. And will it reduce the total volume of international trade? Probably yes.
On that note, thank you so very much.
Thank you. Thank you, Professor Gantz, for this fascinating and enlightening conversation. Professor Shepard, thank you so much for facilitating. It's fantastic. All right. There's lunch, please, everyone.